ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Hello, I am the loud little ducky. It's been a few weeks since I have been able to get back on stream and talk about it. And there's just been so much going on in the Owens verse with Gingras, mainly since I was last able to get on and talk about it. So much stuff has been happening. So we are going to go over the bar charges for David Gingras. I know many people have covered it, and Gingras has been going off quite a bit. So I want to go over what James Bar Guy Lee has put. So let's go ahead and jump into it. And I am going to pull up. I say I'm going to pull up. I should have had all this ready to go, but I didn't. Okay. All right, here we go. Add to stage. There we go. Maybe not me so big. I need more layouts. I wonder if I can edit this one. Can I make this one bigger? Yeah. Let's do that. Okay. All right. There we go. All right. Sorry about that, guys. All righty. So this is James Lee, Bar, Craig Henley, who is Senior Bar Counsel of the State Bar of Arizona. And it says, before the presiding disciplinary judge in the matter of a member of the State Bar of Arizona, David Gingras, respondent, and then it has his bar number. And this is an amended complaint that we're going to go over. I'm not going to go over the original unless there's something in the original that doesn't get the point across. So, amended complaint is made against respondent as follows. Introduction. Respondent represented Laura Owens in Maricopa County Superior Court regarding a motion for sanctions filed against her in a paternity case she had filed. Oh, okay. Yeah, that is kind of basically what it was. After being hired by Owens, respondent became aware, based on his investigation and research, that she had made contradictory statements about her actions and had altered at least one medical record. He had to have known that, And if he didn't know that, he shortly knew it after he put out his request for information about this case. So he knew these things. Despite being aware that Owens had given contradictory versions of events and altered at least one medical record, respondent failed to withdraw as counsel for Owens, or alternatively, failed to diligently investigate and research the relevant facts, pursued claims that were without merit, prepared an affidavit for Owens to sign that included false information, failed to take steps to address false statements that Owens made during her deposition and 2 hearings, and presented Owens' false testimony to the court. And so he was not around for the deposition, but he is able to correct the record after her deposition. And he needs to try to mediate or remedy the screw ups that she made in that deposition. And he, in his mind, he's gonna say he didn't think her claim had no merit because she had the right. In his mind, he thinks she had the right to file the claim because she believed it. But you need to find out if there was reason for her to believe it, not just, you can't just trust. You need to verify. I need to tell my daughter to close her door. Okay. During the period of representation, respondent failed to comply with a court order directing him not to disclose outside of counsel for the parties any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. And Gingras has a lot to say about that, which we will go over later. During the period of representation, respondent took steps to prevent Maricini, a potential adverse witness, from appearing and testifying at a hearing held on June 10th, 2024, which, yeah, he did. He may not think so, but trying to get somebody to do a restraining order is one thing. Your actions prior to all of this is another thing. And you had already been told no, 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 no. During the period of representation, respondent made public disparaging remarks on social media about members of the public and Maricopa County Court Superior Judge Julie Mata, who presided over the paternity case filed by Owens. During the period of representation, respondent filed and pursued a non-meritorious appeal. The appeals court definitely said that. General allegations. At all times relevant, respondent has license to practice law in Arizona, having been admitted to practice in Arizona on October 21st, 2024. Count 1. On August 1st, 2023, Laura Owens filed a per se petition for the court order for paternity and legal decision-making, parenting time, and child support. Petition for a court order for paternity against Clayton Eckerd in matter of Owens and Eckerd, Maricopa County Superior Court. There and thereafter is going to be called the paternity case. Petition for a court order for paternity alleged that Owens had become pregnant by Eckerd. On September 14th, 2023, prior to respondent's involvement in paternity case, Owens filed a pro se expedited motion to seal court record, asking the court to seal the entire record in the paternity case. Owens attached to that expedited motion to seal court record copies of several email messages from Eckerd to Owens in which he sought evidence that she was pregnant. Eckert asserted in the email messages that Owens was not pregnant by him. And never undergone an ultrasound. C had offered illogical excuse to delay testing and had provided him with a sonogram that had been created from an image on the internet. Along with the email message attached to the expedited motion to seal court record was July 25th, 2023 email message from Eckerts to Owens, which reflected that Eckert believed that Owens had provided him with a false sonogram. As well, indicated that Owens had failed to provide Eckert with evidence that she was pregnant by Eckert. And that's the key thing, is failed to provide evidence that she was pregnant by Eckert. Not that she was possibly pregnant, but that she was pregnant by Eckert. She has to prove that, and she would have had to prove it even if there was babies, so that Clayton's not paying for somebody else's baby. Let's see. Owens, September 2023, expedited motion to seal court record and other documents in the court record, including Eckert's email message to Owens, placed respondent on notice that he needed to be diligent in ensuring. Where did I go? Ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckert was the father. So David is going to say, well, she had P tests. So that was the legitimate record that she thought she was pregnant. But you needed to look at more than that. You also have to know the orders and everything else, like the case file itself. What is in the case file? What orders has the judge issued? You have to go over every single motion. And you can watch the videos of the hearings instead of having to, unless you want to read the transcripts, but you could watch the hearings yourself. He had access to do that. Respondent had a duty to diligently investigate and research everything that Owens told him or provide to him. Respondent failed to diligently investigate and or research Owens' allegations to determine whether her statements to him, opposing counsel, and the court were truthful, or that the sonogram provided to him and used during a court hearing on June 10th, 2024 was an image created by an ultrasound performed on Owens. He needed to track down where the real original sonograms were. That's what he needed to do. He had a duty to do that. And Laura, his client, is the one is supposed to have access to all that. They're her medical records. She can get them. But he just was like, well, this is what she told me. I'm sorry, that's not good enough. You can't do that. Hello, everybody coming in. Hello, Bruce. Hello, Texas Packet. On January 3rd, 2024, Eckert's counsel filed a motion for sanctions pursuant to Rule 26 of the Arizona Rules of Family Law Procedure, Rule 26, in which he requested that Owens be sanctioned for filing the petition for court order for paternity and later documents for improper purpose and without medical evidence to support her claim that she was pregnant. Eckerd's January 3rd, 2024 motion for sanctions pursuant to Rule 26 placed respondent on notice that Eckerd had claimed that Owens was not pregnant, which created a duty on his part to ensure that his investigation and research thoroughly addressed everything that Owens told him or provided to him. On February 21st, 2024, Judge Mata issued a minute entry order, scheduled a hearing in the paternity case on June 10th, 2024, to address the issue of sanctions and attorney's fees related to the paternity case filed by Owens. On March 11th, 2024, Eckerd's counsel filed a motion to compel, which stated in part that Owens had testified at her deposition that she had altered a sonogram, falsely claiming it came from Southwest Medical Imaging. So if David knew about her deposition, which he should have, and he had been told about, but even if the public didn't tell him, then if the public hadn't told him, it's his job as a lawyer to go and find that information from the reputable sources, from your client. You, as her attorney, should be getting her medical records. Based on the file, or based on the March 11th, 2024 motion to compel, respondent was once again placed on notice that he needed to be diligent in ensuring that Owens was truthful about her health and alleged pregnancy, medical records and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckerd was the father. So that's interesting that the bar is focusing on she needed to prove that Eckerd was the father, which, yeah, I mean, that's what it originally was about. But David, his rational thinking was she just had to show she was pregnant or believed she was pregnant in order to file this. And that she needed to believe that she was pregnant with Eckerd's baby. And she can't have that belief that she is pregnant with Eckerd's baby with 2 blowjobs and sleeping with at least one other man during this time period. There's no good faith in filing that at this stage. It would have made more sense to file it against the other dude that you actually had intercourse with. That's just me. And she didn't get in trouble for necessarily filing because she thought she was pregnant. Like, we don't think she had a basis for it, but it was her behavior in the case. And the lying and altering documents and getting on the stand and speaking to new information that is not backed up, that you didn't disclose to anybody. I'm going to assume you didn't disclose it to your lawyer that you went to Planned Parenthood Los Angeles. And if you did, and David knew that you were going to say that, he had a duty to let Woodnick and them know about this Los Angeles thing. And that wasn't done. On or about March 2024, Owens hired respondent to represent her regarding the motion for sanctions pursuant to Rule 26. On March 25th, 2024, respondent filed a notice of appearance on Owens' behalf in the paternity case. Upon agreeing to representing Owens, respondent had a duty in preparing her defense for the motion for sanctions pursuant to Rule 26. Let's okay, yeah. When he came up on the thing, because when Gingras came on, Rule 26 was still on the table. It wasn't till like a week into Gingras representing Owens that Rule 26 was taken off the table. But there still was going to be not only sanctions, lawyers should be rule followers. And if they're not going to be, goodbye. I think that there are more lawyers that need to be disbarred that aren't, and that they don't act. I had some good garlic bread over here near my work yesterday. It was so good. It's a little place like over in like Hurst Euless Bedford area. But it was really good. Sorry, chat distracted me. Love my carbs, love my bread. All right. So, like I said, Rule 26 was still on the table. There were also other sanctions that were on the table. All right. So, but he needed to represent her at the June 10th hearing to A, diligently investigate and research both parties' assertions and documentations, because that's what a good lawyer does. Carefully review the entire court record in the paternity case and related cases between Owens and Eckerd. C, review the file provided to him by Owens' former counsel. D, review the information and documents provided to him by Eckerd's counsel. And E, review other information that came to his attention. On March 26th, Eckerd's counsel filed a motion for relief from judgment based on fraud, hereinafter motion for relief from judgment, in the matter of Owens and Eckerd. I like how they say Owens and Eckerd instead of Owens v. Eckerd. Maricopa County Superior Court, All right. An order of protection case. On March 26, 2024, motion for relief from judgment stated in part. The way I'm doing this formatting, I don't necessarily like, but stated in part on October 6, 2023 and October 25th, 2023, plaintiff Owens committed fraud, underlined, when she filed her underlying petition for order of protection and then testified before Judge Duty under the fraudulent pretense that she was pregnant with defendant Eckerd's twins, quote unquote. And the defendant Eckerd was cyberbullying her by posting her medical records online. To be clear, plaintiff Owens was never pregnant by Eckerd, as they did not have penetrative sexual intercourse. Bold typeface and underlines in original. So he's saying here that when he is representing these things, it's not him that is putting the bold and the underlined. It is that when this is how it was written in the motions, and he just copying it from the original and putting it in here the way it was written on the record and in the court. So this is not Jim boldening and underline things that he thinks are important. It's just the way it was written in these motions, if that makes sense. That motion for relief from judgment further stated that Owens had admitted during her deposition that she had modified the medical records, which the court relied upon to grant an order of protection. Which is interesting because I wish they would have gone and dealt with that to say she got this by relying on a sonogram that is not hers, that was obtained fraudulently. So she did get that based on fraud. That motion of relief from judgment noted that Owens had provided no verifiable medical evidence to support her alleged twin pregnancy and had admitted that the ultrasound at the core of this court's basis for granting the protection order was de facto fraudulent. Underlines and italics in original. That motion for relief from judgment contained additional information relevant to the paternity case. That motion for relief from judgment again placed respondent on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records, events, and determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckerd was the father. Those issues were relevant to the motions for sanctions pursuant to Rule 26. We needed to know that she was being truthful about her medical records and her health and the pregnancy. We needed to make sure that there wasn't anybody else. Now, could she lie and say, no, it was just Clayton? There was nobody else. And if Laura doesn't admit to it, that's him. That's not him knowingly saying that Laura wasn't with anybody else. Now that he has seen an investigative report, he can say, hey, it is found to be this. She can weasel some other thing about it, and then he can choose to, he can use it to argue and, take it as his belief. And he's not going to be able to get, that dude's records. And she probably deleted things in her phone. So even if she was like, hey, here's my phone, and, he's not going to subpoena her phone records and stuff like that. So, but he needed to determine whether this stuff was accurate and truthful. And the fact that Owens was pregnant with Eckerd's baby. Not that she was just pregnant, but that Eckerd was the father. Those were issues that were relevant to that June 10th hearing. On April 9th, 2024, respondent filed a notice of appearance and notice pending motion on Owens' behalf in the order of protection case. On April 22nd and May 9th, 2024, respondent provided Eckerd's counsel with supplemental disclosure statements that failed to adequately address Owens' changing version of events. On June 10th, Judge Mata presided over the hearing to address Eckerd's request for sanctions and attorney's fees. During that June 10th hearing, 2024, Owens provided false testimony about matters pertaining to her alleged pregnancy. Respondent failed to correct or clarify Owens' false testimony during direct examination or redirect. Yeah, he needs to clarify that Los Angeles Planned Parenthood shit. Not, oh, I'm just going to leave that and hopefully she believes it. Hopefully the judge believes it. No, you don't get to just leave fake shit out there. All right. On June 18th, 2024, Judge Mata entered an under advisement ruling regarding the June 10th, 2024 hearing, in which she found that Owens failed to meet the burden of clear and convincing evidence that Eckerd was the father of Owens' alleged pregnancy. The footnote says the under advisement ruling did not specify the disclosure violations other than to state that Owens presented new information about an ultrasound at the hearing and testified on the day of the hearing that she anonymously sought care from Planned Parenthood location Los Angeles, in which had never been previously disclosed. And that is on Laura and her attorney to disclose that information. We can't just drop new things into a court. Like you see it on TV and in movies and stuff, but that is not how court goes. Everything that your side like the defense side knows, the plaintiff side knows. Everything the state knows, the defense should know. It's just how it is. Owens acted unreasonable when she initiated litigation without basis or merit. The petition for a court order for paternity was premature at best, which meant she should have just waited. She shouldn't have filed this so early. That would be an innocent explanation. But her behavior doesn't err on that side. As somebody that was like in Gingras' scenario that he talks about, where there was a woman who thought he was the dad, and she was wrong about him being the dad. If that was the case here, and Eckerd just so happened not to be the dad, that would be one thing. That she was just mistaken. But her behavior in the case and doing all the things, the manipulating evidence, not disclosing things, lying about things, all of that does not go with somebody who just was my bad about the dad. My bad about thinking I was pregnant with his kid. So the judge is saying that is at best what is happening, is that she filed this too early. Premature at best. Owens repetitively failed to comply with the Family Law Rule 49 regarding disclosure. Even on order of this court, Judge Mata did not find the respondent had failed to comply with the disclosure or discovery rules. Did not find that respondent. Okay, let's keep going. The court's April 4, 2024, ordering compelling disclosures. Owens acknowledged that she altered HCG test results, which is HCG is human chorionic gonadotropin test, is a medical procedure used to detect pregnancy. And then the other one is about what an ultrasound is. All right. And an ultrasound or sonogram. The petition was not filed in good faith. The petition was not grounded in fact or based in law. The petition was filed for improper purpose, such as to harass the other party, to cause unnecessary delay, or to increase the cost of litigation to the other party. Owens provided false testimony as viability of the pregnancy in the paternity case because she kept moving when she lost the pregnancy, but she was still growing a belly. It makes no sense. The order of protection case and injunction against harassment case filed by Eckerd and Owens knowingly presented a false claim and knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25415. not Rule 26. This is where you needed to argue the law, Gingras, not Rule 26. On August 16, 2024, Judge Mata issued an order, reapplication for attorney's fees and costs, directing Owen to pay a total of $149,219.76 in attorney's fees and costs to Eckerd within 180 days. We are well past that, and nothing has been paid. Let's see. Respondent violated Judge Mata's February 21st, 2024 order. So everything that we did before that we were reading was out of Judge Mata's ruling. So now we have number 40. All allegations set forth or incorporated herein as set forth in full. Basically, everything I stated before. I'm not going to write it all out again, but here it is. That stuff there, let's put it here too. On February 21st, 2024, Judge Mata issued a minute entry order in the paternity case regarding the status conference held on that date, which stated in part, it is further ordered denying counsel for petitioner Laura Owens oral motion to reconsider regarding the ruling concerning petitioner's motion for confidentiality. Further, discussion is held regarding discovery and disclosure. Counsel for petitioner Owens addresses the court with an oral request to have the court order his client provide medical records pertaining to the pregnancy only. Let the record further reflect that no party shall disclose outside of themselves any medical or other documentation, exhibits, medical records, etc., disclosed between the parties. So, no parties. And Gingras has tried to write about this. No party shall disclose outside of themselves. So, medical disclosure and other documentation, exhibits, medical records, etc., are to be disclosed to anybody other than the parties. So, Owens and her attorney and Eckerd and his attorneys is who it should be disclosed to. Notice we didn't get exhibits in a lot of the filings. We only got certain things if David attached them publicly. Woodnick wasn't out here publishing this stuff and putting this stuff out. It is further ordered that the records be disclosed dating back to August 2020. So anything from August 2020 to present. Capitalization, bold typeface is in the original. So it's basically, this is what the order said and looked like. On April 1st, 2024, respondent filed a motion for extension of time to respond to respondent Eckerd's March 11, 2024 motion to compel, hereinafter motion for extension of time to respond, to which he attached a declaration that he signed. Yeah, that long-ass document. When he could have just put in a simple request yes, if you're told you cannot disclose medical information of either of those parties, you cannot disclose that to anybody at that time while you're under that court order. You can't go put them on your blog, because that was the whole reason Laura was supposedly requesting it, because she says that people on Reddit were disclosing her medical information, even though she's the one that was disclosing it. And she's the one that was putting it out there. And Clayton put out like a sonogram or shared a sonogram. And So, yeah, it just do not put it out there into the public. It needed to stay between the parties and the court. That's it. But getting back to this motion to compel and motion for extension of time, Gingras wrote this long ass thing. When if he could have just said, "Hey, I just got on this case. There is a lot of stuff in it. Do you care if I take this amount of time to respond to this stuff?" And had he had come in and been maybe polite to even Woodnick, um, maybe Woodnick would have been like, "Yeah, sure, take all the time. Good luck to you. I'll agree to, a week extension or something." But the way Jingers came in and the fact that he had all this time to draft up a response that was the length that it was showed he wasn't using his time wisely. And instead of drafting up this long ass thing, he he could have been reading the whole time that he was typing all that shit. He could have been reviewing everything. All right. Um, Also, the fact that attorneys, and it's not a criminal case. That's the thing too, is when you get to criminal case is a little bit different because you're taking somebody's liberty away, but in these like family court matters and like civil stuff, a lot of times you're coming into the case and you're accepting the case as is, where it stands at the time. You can ask for an extension of time, but you also know that the judge doesn't have to give it to you. And so if the judge doesn't give it to you, are you ready to accept this case and do the job? Obviously, Gingras still accepted the case and continued to do a job. Well, I don't know. I don't think it was adequate, but um, he knew that this was a possibility, and you can whine about it all you want, but it's not a criminal case. She's not she's not losing her liberty because she didn't have time to respond on this motion to compel. And I don't know why it's so hard to compel because she should have had all this lined up. She has this mountain of proof that she was pregnant and that all this happened, and this should have been ready, available. Here's my medical records. Here's these portals where you can pull up these things. Here's my doctor's note. Here's my doctor's phone numbers. Here's where I went. You can get the records, or she could have gotten the records. She could have gone and got the a sonogram disc or the sonograms itself. She could have done all this in prepping for the trial. So she really just should have handed over what she had, but she didn't have shit. And so otherwise she could have just done it. She didn't need to be compelled. Most women that are actually pregnant have no problem. They're like, "Oh, MFer, you don't think I'm pregnant with your baby?" Bam. Bam, bam, bam. Call my doctor. Do this, do that. I'll show you. They're not like, I don't want to hand over any of this information. Even though I don't want him to know where I got anything, but I am going to want child support and visitation schedules and stuff like this. Well, you got to prove that he's the dad, ma'am. And if you can't prove that, I'm sorry, you're not getting any of it. It's just so stupid. Tell me a woman that's trying to go to court for custody and parenting and child support, and they don't have all their shit to be like, "Nah, you are the father. Here's this, 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 and this. Let's go take a DNA test now. And we can go right after this. Here's a toothbrush. I brought it to court. Here's all the pictures. Here's the birth certificate." Like, they come prepared because they are like, "You are not getting out of this. You are not going to shuck your responsibilities and go live your life and do everything while I'm stuck with the kid having to pay everything by myself." Like, women that are going to court for this stuff, they don't act like this. It's just not how it is. All right. Um Motion for extension of time, re- reproduction of portion of Owen's lab results history dated June 1st, 2023. Uh, Portion of unable to process request, notice from Banner Health regarding Owens, and a portion of a receipt from Banner Urgent Care regarding Owens dated back to June 1st, 2023. And that's the thing. Why is everything is a portion of it? Why can't we have the full document? I don't know if they ever got the full documentation from all those places. I'm sure they did because she signed that waiver. But at first, it was just pictures of portions of things that she wanted to show. Yeah, most of the time we're not worried about our HCG levels. It's just not a thing. The only reason that we ever really think about our HCG levels is if our doctor brings up, "Hey, your HCG levels are at this. They really should be this," when they do some blood work, which could show the doctor that the pregnancy is not where it should be. It's more of an alert to the doctor than it is us. So unless you go looking and you're like, "Oh, this is what my HCG is," it's a lab for the doctor mainly, not for the patient. It helps the doctors treat you, but there's either a baby or there's no baby. We don't give a shit about a HCG. Do I have to eat for 2 or 3, or am I eating for myself? Do I have a reason to gain weight, or am I just getting fat? Like, it's just not hard. And all right, respondent included the following in his April 1st, 2024 declaration: a reproduction of a portion of Owen's lab. Okay, that was a portion and portion and portion. Okay. Unable to process request, notice from Banner Health regarding Owens, copies of messages between Owens and Dr. Joshua McCool. Respondent knowingly violated Judge Mata's order by disclosing information and documents related to Owens' medical records in his motion for extension of time to respond and declaration. Respondent failed to file a motion to seal either his April 1st, 2024 motion for extension of time for his declaration, despite Judge Mata's February 21st, 2024 minute entry order. On April 1st, 2024, respondent posted the following on his law office blog. On October 16th, 2023, Laura had a blood test done at any lab. Want to guess what the results showed? Pregnant. But don't take my word for it. The report can be viewed right here. The underlying text was a link to Owen's October 17th, 2023 Sonora Quest Labs medical report. Yeah, and had he not posted all of this medical stuff, we wouldn't even know about it. Respondent knowingly violated Judge Mata's February 21st, 2024 order by including a link on his blog that led to Owens' October 17, 2023 Sonora Request Lab medicals report. On April 4th, 2024, Greg Woodnick, Eckerd's counsel, sent email message to respondent, which stated in part, I am also not certain why you're publishing court documents and your client's personal medical records contrary to court order. Laura Owens needs to comply with the order and provide disclosure. And Gingras is like, well, she wanted Clayton to stop, not her to stop. There's no proof that Clayton did a whole lot of shit that Laura says. That email message from Attorney Woodnick placed respondent on notice. As of April 4th, Gingras had notice that he should not be posting all this shit out on the internet. And that he needed to take action to seal Owens' medical information and documents. Yep. Despite notice from Eckerd's counsel regarding his violation of Judge Mata's February 21st, 2024 order, respondent failed to file a motion to seal Owens' medical information and documents that he had disclosed in his April 1st, 2024 motion for extension of time to respond and attached declaration. He didn't need to submit all this shit in his extension of time response. None of that was needed. Hey, I just got on this case. Not here's this, and this. Like, just send the stuff over to Woodnick. You don't need to put it in your motion. Just say everything has been complied with. We've sent over everything that we have. On or about April 19, 2024, respondent posted on his law office blog and or other social media the content set forth in Exhibit A to his complaint, which included a portion of one of Owens' medical reports. On April 26, 2024, a Friday, at approximately 5:52 p.m., respondent filed petitioner's response to respondent's amended motion for relief based on fraud. Hereinafter, April 26, 2024, response. Yep. All right. They don't. Respondent's filing of the April 26, 2024 response did not, at the time he filed it, become a matter of public record. The April 26, 2024 response included a summary of portions of Dr. Dean's and Dr. the expert report, which they had prepared for Eckerd. Page 8 through 11, under the heading Miss Owens was pregnant, discussed Dr. Dean's and the expert and quotations taken from Dr. Dean's and their expert report appeared near the bottom of the page 10. Attached on April 26th response was a copy of Dr. Dean's and the expert's report and Dr. Dean's curriculum vitae. Let's see. The April 26th response discussed the report provided by Owens' medical expert, Dr. Medchill. Attached to the April 26, 2024 response was a copy of Dr. Medchill's expert report and curriculum vitae. Yeah, because that's where he was like, I would say it's like a softball 2 is what Dr. Dean says. Apparently not. Apparently she hit that shit out of the park. Also attached on April 26th response were copies of Owens' medical records and other documents relevant to Eckerd's claims. Owens' affidavit dated April 16, 2024, included information from Owens' medical records and portions of her medical reports/records. At approximately noon on Saturday, April 27, 2024, respondent posted on his publicly accessible personal X, formerly known as Twitter, account, his law firm website, and or a social media link to, among other things, his April 26, 2024 response, which included portions of Owens' medical information and documents. Respondent knowingly violated Judge Mata's February 21st, 2024 minute entry order by posting Owens' medical information and documents on his X account or other social media account. So he posted that on the 27th. Woodnick put him on notice on April 4th, and he should have known about the order prior to, just doing his due diligence as a lawyer. But let's say he hadn't had time to review that, which he should have. But by April 27th, he damn well knew, don't be doing this shit. But he doesn't care. Rules for thee, but not for me. On April 29th, 2024, the Maricopa County Superior Court's office docketed respondent's response, at which time that document became public record available to public through the clerk's office. Neither Deans nor Jessica Linde consented to the publication of their export report because it contained a review of Owens' private medical records, which was intended solely for the attorney and the court's review. Yeah, the judge needed to see it because she was the finder of fact. Like, we don't get to see the reports. Usually the reports on experts and stuff like that, a lot of times those are not entered into evidence. It's just what they testify to, or maybe they have a demonstrative aid, but those aren't like evidence. The demonstrative aids aren't. It's just to show you while they're talking. At no time did respondent file a motion to seal Owens' medical information or documents. His April 26, 2024 response, despite Judge Mata's February 21st, 2024 minute entry. Hello, Miss Jupiter James. Ethical violations related to respondent's violation of Judge Mata's February 21st, 2024 order. By engaging in the conduct set forth above, respondent violated ER 3.4C by knowingly violating Judge Mata's February 21st, 2024 order and court rules, ER 3.6A, by making extrajudicial statements that he knew or reasonably should have known would be disseminated by means of public communication and that would have substantial likelihood of materially prejudicing the paternity case. ER 4.4A by using means that no substantial purpose other than to embarrass, delay, or burden any other person. And under Rule 54C by knowingly violating Judge Mata's February 21st, 2024 order. We really didn't, it helped us in determining how much of a liar Laura Owens was and things like that. But really and truly, it's not our business to know that stuff. We just know it because it was put out there. And then once it's put out there, shit's out of the bag. Respondents effort to preclude Michael Maricini from testifying on June 10th, 2024. All allegations set forth herein. Laura Owens obtained a domestic violence restraining order, DVRO, against Michael Maricini in California, which was renewed and extended to September 11th, 2025. That DVRO required Maricini to remain at least 100 yards away from Owens. During the course of the paternity case, Eckerd's counsel disclosed to respondent that he intended to call Maricini as a witness. A few weeks later, just before the disclosure/discovery deadline, Eckerd's counsel informed respondent that contrary to information respondent, had been given by Maricini's California attorney, Maricini would appear and testify at the hearing. Neither Eckerd's counsel nor Maricini nor respondent filed a motion in the San Francisco County, California Superior Court to modify the terms of the DVRO to allow Maricini to testify in Arizona. So they're saying, yes, there was like a subpoena, but the subpoena was not given by California. It was given by Arizona, which means you can't fully subpoena and all that stuff. But they can come willing to testify. Like nothing bars them from doing that unless the judge says no. But the judge approved it, so we move on. On April 30th, 2024, respondent filed a motion in limine asking the court to preclude Maricini from testifying because A, his testimony would elicit improper Rule 404B evidence, and B, Eckerd's counsel had allegedly failed to comply with the disclosure rules regarding the nature of Maricini's testimony. Respondent did not reference the existence of the DVRO in the motion in limine. So when he first wrote in his motion for limine, he didn't say, hey, he can't come testify because there's a DVRO on him. He said that Eckerd's counsel didn't comply with disclosure things with Maricini, and it was improper 404B evidence, which it wasn't proved. It was to show a pattern, not to say that she did it here, supposedly, so she did it here. It was just this, and things like that, which ultimately didn't even come in anyways. Also on April 30th, 2024, respondent filed an emergency motion to strike and request for immediate telephonic scheduling conference herein after emergency motion to strike, which intended a request for an immediate scheduling conference to address whether Eckerd's counsel would be permitted to call 3 newly disclosed witnesses, one of whom was Maricini, at the June 10th, 2024 hearing. On or about May 7th, Eckerd's attorney subpoenaed Maricini to testify as a Rule 404B witness at the hearing scheduled for June 10th, 2024. Maricini was aware of the paternity case and agreed to voluntarily appear and testify in Arizona on June 10th, 2024 hearing. In an email message from respondent to Eckerd's counsel on May 8th, 2024, respondent stated, "This goes without saying, but to the extent that I suggest that Mike Maricini would be arrested if he comes to court in Arizona, that suggestion is completely and totally withdrawn. Not that I didn't say it, but I'm just withdrawing that I said it." Like just some takesy backsies right now. I only said that because I didn't want Mike to show up without giving me the chance to at least interview him, as I would with any normal witness. They don't have to talk to you. A lot of times, like if you've seen a lot of things, like you'll hear attorneys ask all the time, "We've never met, right? Like we've never talked." Um, but Gingras couldn't even go up to Mike and say that, "Oh, we've never met." No, we've never met, but we have emailed. Because Maricini was like, "You know what? Blah, 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 blah," in his text or his email, which told him, "This is what I'm going to testify to." There you go. As long as Mike agrees to have a reasonable call. Nobody says that you have to have a call with somebody to answer some questions. It can be text, it can be email, it can be It can be a phone call. It can be a video conference. It can be a face-to-face, but you don't get to choose which way somebody communicates with you if they have to communicate. Yes, wine. Right. And he would have to prove that before Mike got the subpoena and traveled to Arizona, that Mike had to have known that he actually wasn't to be compelled by that subpoena. Like, if I got a subpoena, I would be like, "Oh, I've gotta go." That's what I would have thought. Now I know that another state technically can't compel you to go. They can't they can subpoena you all you want, but they can't compel you to go. You have to voluntarily agree to it unless, like, Arizona was trying. Like, I live in Texas, so if I needed to go testify in Arizona, they would have Arizona couldn't tell me, "Hey, you have to come to Arizona." In order to compel me and force me to go, Arizona would need to have Texas tell me, "You have to go to Arizona," because Texas can compel me, but Arizona can't. And that wasn't done here, which I get. But most people don't know that unless you follow court stuff and you learn it. No, it's not common knowledge. Most people don't know that. Let's see here. Let's say stipulate and agree that his appearance in AZ is not a violation of anything and will not expose him to an arrest or other legal consequences. Maricini did not make himself available for respondent to interview. He still emailed him. On May 24th, 1st, 2024, Judge Mata issued a minute entry order denying respondent's motion in limine. On June 3rd, 2024, to preserve the issue of the propriety of Maricini testifying on June 10th, 2024 hearing, respondent filed a pretrial statement that addressed that issue. In that pretrial statement, respondent explained that it would be a crime for Maricini to violate the California DVRO, and that any violation of the order by Maricini would subject him to an arrest. The pretrial statement also stated that the issue had been reported to court security by undersigned counsel, respondent, who was requested that Maricini be arrested if he violates the DVRO as the law requires. Also on June 3rd, 2024, respondent called security personnel at the Maricopa County Superior Court and spoke with Officer Gibbs, informing him that Owens had a valid DVRO from California and that she was concerned that he intended to violate the order by appearing at trial. So days before trial, Gingras is telling people, calling the courts, everybody saying, this dude shows up, this is what's happening. There is a valid thing that y'all are going to need to do. So when Gingras is like, Laura was there and she was scared. No, this had been planned. It wasn't that she saw him and then that's just when everything, he was just trying to help her. They had been planning this since the June 3rd, at minimum, if not before then, all the way to at least June 10th. Also on June 3rd, 2024, respondent sent an email message to Officer Gibbs, to which he attached a copy of the California DVRO. Respondent's June 3rd, 2024 email message to Officer Gibbs stated that court approval for Maricini to appear at trial has not been granted and the DVRO continues no exceptions for in-person contact like this. And courts just cannot be run this way. That people can't come in and say their piece because, good lord, there's already craziness with people that don't need protection orders getting protection orders. If you could get protection orders just to keep people out of court all the time, like, it would be worse than ever. Judge Mata had previously denied respondents' April 30th, 2024 motion in limine to prevent Maricini from testifying, but had not yet ruled on his objection to Maricini's testimony, which he set forth in petitioner's pretrial statement filed on June 3rd, 2024. Respondent also claimed in his June 3rd, 2024 email message to Officer Gibbs that if Maricini appeared in court, he would clearly violate the DVRO. Respondent additionally claimed in his June 3rd, 2024 email message to Officer Gibbs that due to the short time before trial, he cannot raise this issue with Judge Mata before next week. Yeah, you can. You did. She doesn't give a shit. And guess what? Who also didn't give a shit? The California judge. When it went to Clayton and Greg being there. So California probably would have been like, yeah, sure, Mike, go. I don't know why he's decided to die on the hill of Laura Owens. I don't get it. It's one thing to zealously advocate for your client, but to do the things that he was doing is not zealous advocation. It's truly like I've never seen before. All right. On June 4th, 2024, Eckerd's counsel sent an email message to Officer Gibbs and Judge Mata's court stating that a valid subpoena had been issued for Maricini's appearance. Respondent was copied on that email message. Which, yeah, it's not, I mean, it's a subpoena and it is a valid subpoena, but it's not a forcible subpoena, maybe? I don't know if there's another word for it. Eckerd's counsel suggested in June 4, 2024, email message to Officer Gibbs that respondent's acts of requesting law enforcement to enforce Owens' DVRO qualified as an attempt to intimidate a witness as set forth in ARS 132802. Sometime prior to June 10th, 2024 hearing, respondent sent an email message to Maricini's California attorney informing her that because of the DVRO, Maricini would be arrested if he attended the June 10th, 2024 trial. On the morning of June 10th, when Owens saw Maricini in the parking lot, respondent contacted court security personnel, but he was informed they were unable to help. I don't know if it was the parking lot. She might have seen him in the parking lot, and then it's when they got in the building and all that stuff. I don't know. Prior to commencement of the June 10th, 2024 hearing, court security personnel in Maricopa County Sheriff's Office, MCSO, informed the court that respondent had called 911 from the parking lot. It was from the courthouse of the Northeast Justice Building and attempted to have Maricini arrested for a violation of the DVRO. Judge Mata or a member of her staff through court security personnel and or the MCSO informed responding police officers that Maricini was responding to a valid subpoena and was not to be detained prior to his testimony. So this was prior to his testimony, saying that maybe if they felt like he violated the law or his restraining order, that after his testimony, then maybe you could arrest him if you think he's violating something. They didn't, so I don't know. But that he was not to be detained prior to his testimony. She can't control what they do afterwards, but not right now. On June 10th, 2024, court security personnel escorted respondent and Owens from the parking lot to the courtroom prior to the hearing. Wait, 2802. I wanted to look at that. It was 2802. So influencing a witness, 132802. A person commits influencing a witness if such person threatens a witness or offers, confers, or agrees to confer any benefit upon witness in any official proceeding, or a person he believes may be called as a witness with intent to or 1, influence the testimony of that person, or induce that person to avoid legal process summoning him to testify, which saying, if you try to come testify, you're going to be arrested. So telling him, don't do what you were being told to do, because don't come and testify or we're going to arrest you. You can't threaten people with that stuff. To induce a person to absent himself from any official hearing proceeding to which he has been legally summoned. And influencing a witness is a class 5 felony. Did I see criminal charges? Do I think we will? No. Yep. I just can't imagine doing all this for any client. Like, it's just weird. Okay. At the June 10th, 2024 hearing, Judge Mata allowed respondent to argue on court record before any witness was called his objection to Martini testifying. Well, he put that on the record. Respondent argued non-disclosure as a basis for precluding Martini's testimony, as well as the existence of the DVRO, which I don't think that the non-disclosure argument works, in my opinion. But he said, the second issue, Your Honor, deals with this California court restraining order. I think you have a copy of it. It's one of our trial exhibits. We have a court record from the state of California that prohibits Mr. Martini from being within 100 yards of Miss Owens. He is violating it right now. There is no exception for court appearances. She, Owens, is so terrified that she may not be able to sit here during this trial under the full faith and credit clause of the U.S. Constitution, and also under federal law. This court is required to enforce that order as it is written. You can't change it. You can't modify it. You can't disregard it. And yet, here we are. The thing is Gingras could have asked Martini to not be in the courtroom before he testifies. And he was like, no, I'm not going to do that. You know, he sits there and says, oh, Martini knew that he wasn't going to testify, you know, because of time constraints and all that stuff. In that same argument, Gingras should have known that within the minimum of the 2 hours that they weren't going to get around to Martini testifying. So really, was it going to take away time to have Martini or Greg not be in the courtroom with Laura? But he didn't invoke the rule of sequestration. And had he, then the restraining order could have been followed. But Gingras kind of waived that when he was like, no, that's going to take too much time away. We'll just leave him in the courtroom. You could have kicked him out. You saying you want to protect your client so she doesn't look at him if she has to sit here in the same room as him, you could have made him not be in the courtroom. If it was going to be so bad for her, you would have said, you know what, for my client's mental health and, her fear, and I want her to, be more focused and not worried about him, that few minutes that it's going to take to be like, hey, can you get him to come in here and testify, that it would have taken up in that 2 hours should have been well worth Maricini not being in that room if she was so terrified. He had the option to do it. He chose not to. He chose it wasn't worth the time taking up that it would have been to get Maricini in there when he could have just done it, knowing that they probably weren't going to get around to it. Judge Mata affirmed her prior ruling, allowing Maricini to testify. Yeah, she said he could testify. She let them decide whether he was going to sit in the room or not. Maricini was sworn to testify in court on June 10th, 2024, but never testified. Violations based on respondents' effort to preclude Maricini from testifying on June 10th, 2024. Based on the conduct set forth, respondent violated ER 3.4A and ER 8.4A by unlawfully attempting to obstruct Clayton Eckerd's access to Maricini's testimony, ER 4.4A by using means that no substantial purpose other than to embarrass, delay, or burden Eckerd or his counsel, and ER 8.4D by engaging in conduct prejudicial to the administration of justice. Exactly. Respondents' disparaging comments about Maricopa County Superior Court Judge Julie Mata. And then all allegations incorporate here. Respondent knowingly made unprofessional, disparaging, and inappropriate comments about Judge Mata's qualifications and or integrity in documents filed with the court and in posts he made on social media accounts. First instance, Judge Mata's father's attendance at June 10th, 2024 hearing. On July 8th, 2024, 20 days after Judge Mata entered the under advisement ruling regarding the June 10th, 2024 hearing, respondent filed a notice of change for judge for cause, memorandum and affidavit in support, hereinafter notice of change of judge for cause, which was unprofessional and inappropriately disparaging of Judge Mata. For example, respondent stated the following in the notice. It is difficult to image a more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial in support of a party, while also privately engaging in prohibited ex parte discussions about the case with her father. Footnote 4 says, according to internet reports, Judge Mata's father attended the June 10th, 2024 hearing, over which Judge Mata presided, and was present in the overflow courtroom where the hearing was live streamed. He wasn't in the court with her. They couldn't give facial expression. They could not do baseball signalings or quieting the witness to each other. They couldn't see each other. Also, you don't know that they're privately engaging in ex parte discussions about this case. You don't know anything like that. You don't know that he invited her or she invited her dad to be there in support of Clayton Eckerd either, or in support of Laura Owens. You don't know that. These actions made a mockery of these proceedings, as shown in the video clips submitted here with. Clayton supporters gleefully celebrated Judge Mata's father's participation in the case, even going as so far as to laughingly asking people not to spread information about this participation. because we don't need a mistrial here. No, we don't, because nobody wants to do it again. But nobody wants to deal with mistrials, and that's in any case. But also, if this was mistried and it was tried again or whatever, it's still gonna have the same result. There's not ever going to be a different result than what Judge Mata saw. It's just not happening, especially now that more time has gone by. For once, those followers were exactly right. The conduct of Judge Mata and her father absolutely warranted a mistrial, or more accurately, a retrial before a different unbiased judge. Sure. That's why I was like, you know what? What if nobody wants that, but sure. Put any judge on this and it's going to end the same. I'm sorry, it's just going to. Like, nobody is scared of this case going anywhere because it's such a strong case against her. This shameful conduct by Judge Mata was not only violating Laura Owens' rights, it raises serious questions regarding Judge Mata's fitness as a judge. Any reasonable objective observer in Laura's position would be justified in wondering, was my case fairly decided based on the evidence, or was Judge Mata simply trying to impress her father? Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because of the other party was on The Bachelor. Hee hee. It's so ridiculous. Like, it would be one thing if he just said this in a tweet or on his blog, but the fact that he actually put it into a legal filing. I mean, it's all ridiculous no matter where it's put, but the fact that it was in the legal filing is the most appalling. Assuming the published allegations of Judge Mata are true, as documented on video by Clayton Eckert's own followers. But you said we're all liars. So we could be lying that her dad showed up and him not really be there if we're such liars and we don't ever talk about the truth. Why would you believe us that her dad was there, but you don't believe us about anything else? Makes no sense. Believe us for some of the stuff, but not all of the stuff. I don't only believe the stuff that suits you. That's not how things go. This proves Judge Mata's separately violated Rule 2.9a of the Code of Judicial Conduct and Judge Mata's blatant, pervasive disregard for her ethical duties and her respect for Laura's fundamental rights helps explain the judge's numerous and otherwise heretofore inexplicable adverse rulings during this action. And then he's saying where the italics and all that shit was in the originals. Second instance, screwed up form of final judgment. Sometimes prior to September 3rd, 2024, which was during the pendency of Owens' appeal from Judge Mata's under advisement ruling dated June 18, 2024, respondent posted on his law firm's or personal blog, X, formerly Twitter account, and or social media, the content set forth in Exhibit B to this complaint. Respondent commented above, pertaining to Judge Mata's inadvertently reference to incorrect family law rule regarding the final judgment language in her June 18, 2024 under advisement ruling regarding the June 10th hearing. 1 second. What am I trying to do here? Oh, mute my. Okay, y'all hear me again? Yep, he doesn't know if it's unusual. He doesn't know how often. Was he just in town like your mother was in town? That's true. How much alcohol was involved in all of this? Bruce, can someone just disbar this blogging, limiting bully before bedtime? Bueller, Bueller, Bueller. Great movie. All right. She referenced Rule 78B of the Arizona Rules of Family Law Procedure instead of Rule 78C. She corrected the inadvertent error on February 18, 2025, after the Arizona Court of Appeals remanded the matter to Superior Court. Yep, she fixed that error that she made. Okay. Third instance. Commission of crime. Sometime prior to September 3rd, 2024, during the pendency of Owens' appeal, respondent posted on his law firm's or personal blog. I don't think it's not a personal blog. I don't know why he needs to put that. I mean, I know he's covering his bases, but just law firm's blog. It says Gingras Law. Account and other social media set forth Exhibit C to his complaint. Respondent's reference to Judge Mata committing a crime pertained to her alleged failure to enforce the DVRO against Maricini by allowing him to attend the June 10th, 2024 hearing and be within 100 yards of Owens. Well, I guess the California judge also was going to commit a crime too, because she was allowing Gillespie and Eckerd to be there. So I guess we got crimes on all the judges because every judge in the entire existence of the world is against Owens. The fourth instance, and he's also made more, he's made more blog posts since then of her committing crimes. I believe even since his bar charges came out, he has accused her of more crimes and other people of crimes. So he's still continuing on. Fourth instance, internet posting of public warning. Judge Julie Mata, on December 16, 2024, respondent posted on his law office blog content set forth in Exhibit D to this complaint, which he stated in part that Google is not a valid legal source of evidence. Now, that's funny because you Googled and put in one of your, did you put it in, I think you put it in your court document. Yeah, you put it in your response to this, I believe, a Google search as a valid source of evidence to your Planned Parenthood ID and needing to show who you are. Let's see. So is it a valid source to be citing or is it not? Also, you have no proof she Googled it. Unless your case is assigned to Judge Mata, ellipsis in original. Fifth instance, Judge Mata does not care about the rules. On December 10, 2024, respondent recorded a podcast in which he stated the following. At 27 minutes and 25 seconds, if Judge Mata was a person who cared about the rules, she would have sanctioned Eckerd's counsel. Woodnick for making a false statement about the law and that she could have referred him to the state bar just like she did me. It's not fair. Everybody should have been reported. Woodnick's not out here doing all this fourth, fifth, sixth, seventh instance of doing this bullshit. Violations related to respondents' disparaging comments about Judge Mata. Based on the conduct set forth above, respondent violated ER 4.4a by using means that have no substantial purpose other than to embarrass or burden Judge Julie Mata, ER 8.2a, by making a statement with reckless disregard as to its truth or falsity concerning Judge Mata's disqualifications, or not disqualifications, Judge Mata's qualifications of integrity. ER 8.4d, by engaging in conduct prejudicial to the administration of justice, and Rules 41b3 and 7, by failing to maintain the respect due to the court that Judge Mata, and engaging in unprofessional conduct, including by making public statements about Judge Mata's qualifications of integrity that were objectively false or made with reckless disregard as to their truth or falsity. Disparaging comments about members of the public. All allegations set forth are incorporated here. On November 21st, 2024, respondents sent an email message to Laura Owens and copyright at Reddit, in which he identified himself as a lawyer in Phoenix, Arizona, representing Owens in her case against Eckerd. That November 21st, 2024 email message with respondent made available to Reddit employees when he sent it to copyright at reddit.com, stated in part. Clayton's fans are, generally speaking, total fucking psychotic assholes. Clayton's fan, being the total fucking assholes that they are, have come up with a new plan now. On December 4th, 2024, respondent filed a request for subpoenas to identify infringers pursuant to 17 USC 512H and supporting declaration hereafter called request for subpoenas. Respondent included a copy of his November 21st, 2024 email message as Exhibit A to that request for subpoenas. Violation related to respondents' disparaging comments about members of the public. By engaging in conduct set forth above, respondent violated Rule 41b-7 by engaging in unprofessional conduct. Respondents' meritless claims, false information in an affidavit, and presenting of Owens' false testimony / changing versions of events. Eckerd's counsel disposed Laura Owens on March 1st, 2024, approximately 3 weeks before Owens hired Gingras. During Owens' deposition, she testified that she had an ultrasound performed at Planned Parenthood on July 7th, 2023 in Mission Viejo, California. B altered the California Planned Parenthood sonogram to say SMIL, Southwest Medical Imaging, instead of Planned Parenthood. C had gone to Planned Parenthood anonymously. D added her name to the sonogram. E not changed the date on the sonogram from July 2nd to July 7th. And F altered the sonogram at home using Adobe Acrobat. On March 11th, Eckerd's counsel filed a motion to compel the production of, among other things, the original records from Planned Parenthood Mission Viejo Health Center. On March 25th, 2024, respondent sent an email to Eckerd's counsel stating he would take a trust but verify approach with Owens. But he didn't. He just trusted and didn't verify shit. Approach Owens and that he would actively investigate every detail of what she said, looking for information that contradicted her statements. That we gave him information that contradicted all that shit. He didn't care. He's like, yeah, I know, y'all are verifying all this stuff, but I'm choosing to trust. So I trust and I verified it was all wrong, but I'm still choosing to believe someone even though it's in my face. On March 27, 2024, Eckerd's counsel sent an email message to respondents. To respondent stating that Owens' prior counsel had presented records to the court, including medical records and letters from law firms that were fabricated by Owens. Owens had misused court processes in multiple states to perpetuate the most bizarre of cons for relationships. And 4 men had documented Owens faking pregnancies and fabricating medical evidence. The March 27, 2024 letter from Eckerd's counsel placed respondent on notice that he needed to be diligent in ensuring Owens was truthful about her health, alleged pregnancy, medical records, and events, and B, determining whether any legitimate evidence existed reflecting that Owens was pregnant and that Eckerd was the father. On April 4th, 2024, Judge Mata signed an order granting Eckerd's motion to compel, directing respondent to provide Eckerd with the following, among other things, by 5 p.m. April 19, 2024. All medical records for petitioner Owens from Planned Parenthood Mission Viejo from on or about July 7, 2023. April 4, 2024, order placed respondent on notice that he had diligently searched for all of Owens' medical records at Planned Parenthood Mission Viejo from on or about July 7, 2023. On April 10th, respondent reviewed Judge Mata's April 4th, 2024 order and sent an email message to Owens regarding that order. When respondent asked Owens for information about the Planned Parenthood sonogram, she provided him with her username and password for her Planned Parenthood patient portal. Sounds like they subpoenaed Gingras's records. Or Gingras sent it all over. Who knows? On April 15, 2024, at 1:55 p.m., respondent logged in to Owens' Planned Parenthood patient portal. When respondent logged in to Owens' Planned Parenthood patient portal on April 15, 2024, records reflected that Owens had scheduled an appointment at Planned Parenthood in California under her real name. Yeah, because how are they going to? The thing is if you go anonymously, you're not going to have a patient portal. Because how are they going to know who to set up the patient portal for? Yes, replay crew, love you. Love my replay crew. Always comment. I like to comment back and have discussions in the comment sections as well. But that makes no sense. If she's, how would her information be in her patient portal if they don't even have any idea who she is? Like, it just doesn't logically make sense. She went anonymously. Nobody knew who she was. Well, then why does she have a patient portal to give her medical records that has her name on it? It's just so stupid. All right. Apparently in late June 2023, Owens' Planned Parenthood patient portal also reflected an appointment scheduled for July 2nd, 2023. So there was an appointment for a late June appointment. There was an appointment scheduled for July 2nd, 2023 at a Planned Parenthood location in Costa Mesa, California, located in Orange County. Owens' Planned Parenthood portal did not reflect an appointment at Planned Parenthood in Los Angeles. Where did this late June one, did that show? They didn't say where the late June one was located. They just said the July one, where it was located. And that's the thing too, is this patient portal for Planned Parenthood? I'm guessing it covers all the Planned Parenthoods that are under that parent company. Like, anytime you've ever been to Planned Parenthood, this is where everything would be, no matter what location you were at, possibly. that you wouldn't have a different patient portal for every single location? I mean, you could, but it doesn't sound like that's how their patient portal works. Although respondent had checked Owen's Planned Parenthood portal on April 15, 2024, and knew it did not have records reflecting that Owens attended an appointment or had an ultrasound performed at Mission Viejo location, he never took any steps to correct Owens' false deposition on June 10th, 2024, hearing testimony that her ultrasound was performed in Mission Viejo, or additionally in the case of the hearing in Los Angeles. Also, I wonder, because we just found this out when we read these bar charges, that Gingras logged into her patient portal and Gingras had seen it. And I am wondering if Gingras himself ever disclosed to Woodnick that he had been in her patient portal. How was that found out? Was it that it was disclosed and we as a public just didn't know about it? Or what? Because this is still failure to disclose. They d Yeah, corn-fed, it yeah, it it is so crazy. Their logic just it doesn't make any sense. It's not based in fact or reality. At some point in time, respondent became aware that Eckerd's counsel had unsuccessfully sought copies of medical records pertaining to Owens from Planned Parenthood in Mission Viejo, California, that they couldn't get any records. And Gingras and them needed to say that's because there is no records. Upon learning had not obtained records from Planned Parenthood, respondent was on notice that he needed to be more diligent and more closely scrutinize what Owens had told him. Yeah. You see, well, she made an appointment. Just because you make an appointment didn't mean you went there to get a sonogram. You can make an appointment. That doesn't mean that anybody actually did a sonogram and produced an image for you just because you put an appointment on the books. She ain't admitting nothing. All right. Let's see here. Respondent was aware that Eckerd had alleged in the motion to compel that he, Eckerd, or his counsel had received confirmation from nearly all providers. Oh, a minor. I was like, what does that say, Texas? I get it now. The Owens was never a patient of theirs. And I'm wondering, they're just talking about this date, but I am wondering if her patient portal ever shows her going to a Planned Parenthood ever in her life. Like, would it show when she supposedly went with Greg or with Mike? Like, wouldn't those be in there too in her patient portal? It should be. They just may not be mentioning him here because it's not pertinent to this particular part, but be interesting that she has no records. We know she has no records as from 2020 to date, which encompasses Gillespie, that there's no record of her going to Planned Parenthoods in California for sure. But if Gingras looked at the Planned Parenthood stuff, yeah, this is information he needed to share. That motion compelled placed respondent on notice that he needed to be diligent in ensuring that Owens was truthful about her health, alleged pregnancy, medical records, and events. and determining whether any legitimate evidence reflecting that Owens was pregnant and Eckerd was the father. Respondent learned prior to June 10th, 2024, hearing that Owens had gone to Planned Parenthood, Mission Viejo. Prior to June 10th hearing, Owens told respondent that she had made appointments with Planned Parenthood in Southern California on 2 consecutive weeks, June 23rd to 25th and June 30th to July 2nd. Owens admitted to respondent that she had altered the sonogram prior to the date she hired him. On April 15th, 2024, respondent sent a draft affidavit to Owens to review and sign, after which she informed him by email about some possible changes, including the following. Maybe don't include the ultrasound since I tampered with the top. Like, I don't want MedChill to question my credibility based on that. So I know like he's going to be our expert, right? But in order for him to believe me and say what we want him to say, I don't want him to know about my arts and crafts. Like, he doesn't need to know about my extracurriculars. Like, we haven't known him that long. Because that might change his expert opinion. And you have to disclose shit to your experts. It goes really badly on people. If you've seen in trials, if you've watched many trials where an expert will get up there and they'll be like, I reviewed this. And then defense gets up there and is like, but did you review this? And they'll be like, no, I didn't even know any of that stuff even existed. So you only looked at this thing. Yeah. Yeah. We can't trust your credibility because you didn't have all the information to make the facts. And that was always my thing with MedChill is I didn't blame him for coming to the conclusion that he did because all he could do was form what he thought based on the information that was given. And he was given bad information. And so it's going to be a bad opinion when he's not getting accurate stuff. And that's not MedChill's fault. That is Gingras and Owens' fault. Garbage in, garbage out. So she wants to lie to her expert. Who doesn't she want to lie to? Omitting truth, omitting things by lie is lying. On April 16, 2024, respondent discussed with Owens the draft affidavit he had sent her on April 15th, 2024. Later, on April 16, 2024, Owens executed the affidavit that respondent had drafted and which was attached to April 26, 2024 response to respondent Eckerd's amended motion for relief based on fraud. Owens' affidavit, a portion of which set forth in Exhibit E to this complaint, included an image of an altered sonogram. Respondent subsequently learned that Owens had allegedly gone to Planned Parenthood in late June 2023, but took no steps to correct that false statement in her April 16, 2024 affidavit. That, hey, I know she said that she went here, but she didn't. You need to disclose that to people. This was an error. The sonogram that Owens claimed was from Planned Parenthood, shown above, includes her real name, even though that sonogram was not a sonogram that resulted from an ultrasound that had been performed on Owens. Owens stated in her affidavit under penalty of perjury, however, that she had not changed anything on the sonogram other than the name of the facility and the date. And it said, I showed you the difference between a sonogram that Laura was getting during this time period and my daughter's sonograms that she was getting during this period. and the difference in what they looked like and the information and stuff that was on them. I did black out my daughter's name and stuff like that on them, but you could just see how different they actually were. Um Sonogram claimed that Planned Parenthood shown included the name. However, she had not changed. Okay. During Owens' March 1st, 2024 deposition, she testified that she went to Planned Parenthood anonymously and that she later added her name to the sonogram. Yeah, because if you went anonymously, why is your name on the sonogram if they don't know your name? Respondent Owens' March 1st, 2024 deposition transcript on April 8th, 2024. Okay. Respondent became aware that Owens had falsely testified during her March 1st deposition that she obtained the ultrasound on July 7th, 2023. Yeah, he should have known that that wasn't accurate because he said, what did he say? He said he found, going back for a minute. Oh, I missed it. What the hell happened here? Hold on. It's back here. Right. So he would know that she didn't go on the 7th because Gingras saw in her patient portal that there was an appointment for July 2nd. So nothing about July 7th. So that should have been corrected. It never was. It's just, well, let's just let him think whatever. Can't do that. And yeah, and he never corrected it. Okay. Owens told respondent that she went to Planned Parenthood anonymously and then later at the June 10th, 2024 hearing testified she went to Planned Parenthood using a fake name. Based on respondent's review of the transcript of Owens' March 1st, 2024 deposition, he knew that Owens either A, testified falsely at her deposition by stating she had gone to Planned Parenthood anonymously and subsequently changed the name of the facility and added her name to the sonogram, but did not change the date on it, or signed a false affidavit, which he filed, that stated she altered only the facility name and date. He's like, well, that was a typo. I meant to add that in there. I just omitted a whole bunch of things that would have corrected the record. Respondent failed to take steps to address Owens' false testimony during her deposition to address her false affidavit. Respondent never obtained from Owens the original unaltered sonogram that she alleged obtained from Planned Parenthood in California. Respondent failed to verify with Planned Parenthood whether it treats people anonymously or using fake names. Yeah. You need to verify with Planned Parenthood, not Google, Gingras, that Planned Parenthood treats people anonymously. Or that they treat people with fake names. You need to verify with Planned Parenthood, not Google. Google does not fully know what Planned Parenthood does. And of course, he's like, well, even if Planned Parenthood says that this is they don't do this, who knows if they actually do this? Nobody's treating Laura Owens any like special. Making sure I'm not missing anything. All right. On April 18th, 2024, respondents sent an email message to Owens stating that he told Eckerd's counsel that she went to Planned Parenthood on July 2nd, 2023, but that he had located an email message from her to Dr. Zyman dated June 28, 2023, stating that she had gone to Planned Parenthood the previous weekend. So she's telling Zyman, so Gingras knew that there was a message, an email message to Zyman that was dated June 28th, where Owens told Dr. Zyman, I believe he's her neuroepilepsy whatever doctor, stating that she had already gone to Planned Parenthood as of June 28th. So she's lying to Dr. Zyman about even going. And Gingras knew that this wasn't true, that she had lied about that date to Dr. Zyman. He has proof that she lied to a doctor because he knows, looking at her patient portal, she didn't go anytime before June 28th. So she lied to her doctor. Oh, if she lies, I'm going to drop her. No, you're not. Owens told respondent that she went to Planned Parenthood anonymously, and then later at the June 10th hearing testified she went to Planned Parenthood using the fake name. Based on respondent's view of the transcript of Owens' March 1st, 2024 deposition, he knew that Owens either testified falsely at her deposition by stating she had gone. Okay, we already read this part. I guess, okay, I skipped. Why am I rereading this? Okay, previous weekend. On June 3rd, 2024, Corey Keith, the attorney who represented Owens, immediately prior to respondent's representation of her, filed a notice in the paternity case captioned Ethical Rule 3.3, Notice of Candor, hereafter Notice of Candor. In that notice, Attorney Keith stated that he told the court the following at a status conference back in February 21st, 2024. Owens has not lied in this case. She has not intentionally lied. And that Corey Keith believed that to be true. That if she had made some misstatements about some dates, it wasn't intentional. He obviously hadn't seen the patient portal of Planned Parenthood. He hadn't seen any of her medical records other than the ones that she gave him, all the fake arts and crafts stuff. And he didn't have any verification of if he had that letter, that email that she sent to Dr. Zyman, he didn't have any medical evidence that was contrary to that because they still hadn't done discovery. She wasn't giving any of that over. So nobody prior to Gingras really had anything other than what Laura Owens had. It was not actually from the original sources that they came from. But Keith believed it. Attorney Keith further stated in the notice of candor that based on March 1st deposition testimony, he no longer believed the statements he made on the 21st were true. He's like, at the time, I thought all this was true. But now that I've learned so much, I do not believe these are true anymore, and I need to let the court know that. Because I don't need them coming after me thinking that I should have done all this stuff prior to. But the March 1st deposition is where so much crap came out from her finally admitting to some things. Attorney Keith summarized Owens' deposition testimony in that notice of candor. Attorney Keith included evidence in the notice of candor establishing that Owens had testified falsely before Judge or Commissioner Gilkexis, Judge G, several months earlier in Eckert v. Owens and an injunction against harassment proceeding. Respondent failed to take steps to address Owens' false statements to Judge Gilkexis, Judge G, during the November 2nd, 2023 hearing for the harassment petition. Attorney Keith also noted in the notice of candor that Owens testified before Judge G, among other things, that she had been seen by Dr. Higley last Friday at 14 minutes and 40 seconds into the hearing, but stated during her March 1st, 2024 deposition that she had an appointment with Dr. Higley, but did not attend that appointment. She didn't tell Corey Keith that prior. She told him she went to these appointments because making an appointment and going to the appointment in her mind are synonymous. At some point in time prior to June 10th, 2024 hearing, Owens admitted to respondent that she incorrectly testified before Judge G that she had just been seen by Dr. Higley last Friday, but in reality had only made an appointment to see him. Yes, and I love the way that Deandra went after her on that. Although respondent was aware of the content of the notice of candor, he failed to diligently investigate and research Owens' statements to him, which he presented to the court. Yeah, because he was pissed off that an attorney would be so ethical. Medchild failed to disambiguate actual pregnancy from fraud. I blame him for this failure, which he could have said fraud or pregnancy or consistent with his views. They're never going to say that, though, because they're going to just assume that it's not fraud. I mean, remember, he had the Virgin Mary at Christmas, or Virgin Maria at Christmas. But yeah, I can't. Yeah, they're consistent with pregnancy. That not that it proves that she was pregnant. All right, let's see here. I feel like I missed something. Prior to June 10th, respondent reviewed transcripts and video recording of hearing Owens and Eckerd's deposition transcripts taken before Owens hired respondent. The file maintained by Owens' second attorney, including documents he had prepared and filed. The report prepared by Eckerd's expert witness, disclosed made by Eckerd's counsel, the medical records provided by Owens, and possibly other records and information related to issues of the paternity case. Based on the information that respondent acquired during his representation of Owens, he was aware that Owens had testified falsely before Judge G, made false statements during her deposition, altered a sonogram, which he offered into evidence during the June 10th, 2024 hearing, and or D, signed an affidavit that included false information, which was filed with the court. Yeah. I need to go back and watch that. That he put in the sonogram and said that she got this sonogram at this place. But he's like, I didn't know that sonogram was fake. It could have been another sonogram. I didn't know that particular one. But he knew that there was no Planned Parenthood sonograms. Otherwise, he would have gotten them from her patient portal or from them, and they didn't have any of them. Respondent knew that Owens had not been truthful about facts material to the paternity case, but did not withdraw from the case or take sufficient steps to address Owens' false statements and alter the sonograms. Yet you cannot get up there and argue knowingly false information that you know is not true. You knew by looking at her patient portal and all of that this was not true. And if you even think that it couldn't be true, you do not present it. Because you cannot put your client up on the stand knowing they're going to lie or they're going to perjure themselves. You can't do that. During the June 10, 2024 hearing, Owens testified on direct examination that she obtained a sonogram at Planned Parenthood in California. Owens testified on direct examination that she went to Planned Parenthood under a fake name, which was contrary to her deposition testimony, that she went anonymously. Respondent asked Owens on direct examination if she changed the name on the top of the sonogram. Owens responded, of the location, yes. Owens testified on direct examination that Planned Parenthood sonogram was obtained at the end of June. Owens admitted during cross-examination that she had stated during her deposition that the ultrasound had been performed in Mission Viejo on July 7th. She testified on direct examination that Planned Parenthood's sonogram was obtained at the end of June. That's right, it wasn't even in July that she did it, because before she was saying July, now she's stating June. None of this freaking makes any sense. Owens also testified during cross-examination that she had been staying in Mission Viejo during or late June or early July. Owens further testified during cross-examination that she had changed the date on the sonogram from July 2nd to July 7th, and the July 2nd date was the correct date, but I thought it was late June on direct. Okay. That testimony conflicted with her deposition testimony, where she stated she had not changed the date on the Planned Parenthood sonogram, and her testimony during direct that the ultrasound was conducted in late June 2023. During cross-examination, Eckerd's counsel reminded Owens that during direct examination by respondent, she testified that she went to Planned Parenthood under a fake name. During the cross-examination, Eckerd's counsel informed Owens that Planned Parenthood office for Orange and San Bernardino counties, California, had submitted a letter noting that she had scheduled an appointment for July 2nd, but that the appointment was canceled, and that the ultrasound image she relied upon, which she claimed to have obtained from Planned Parenthood in Mission Viejo, was not consistent with ultrasound images from Planned Parenthood offices in Orange or San Bernardino counties. That's the thing, is even if, and that's where she's like, well, you didn't subpoena Los Angeles. Your patient portal that your attorney supposedly looked at would have had Los Angeles in it. It's all lies. All lies. And he continues to vouch for this bitch. Therefore, after cross-examination, Owen testified for the first time that her appointment was actually with Planned Parenthood in Los Angeles. Well, that's not what your portal said. When asked during cross-examination when she went to Planned Parenthood in Los Angeles, she stated exactly when I said I did, July 2nd. That testimony conflicted with her deposition testimony that she stated she had not changed the date on the Planned Parenthood sonogram, and her testimony during direct examination that the ultrasound was conducted at the end of June. Yep, women have no problem remembering these dates. They also are in your calendar on your phone usually. Or your paperwork, like you have shit to back this shit up. You're just like, I don't know. There was testimony presented during the hearing, the June 10th hearing. Planned Parenthood requires patient to provide identification and does not allow anyone to obtain services anonymously. Respondent did not take any steps during direct or redirect examination to address Owens' false or inconsistent testimony. The discrepancies between the date she testified to during direct examination, the end of June, the date she stated during crossed, July 2nd and July 7th, and then the date she testified during her deposition, July 7th. Violations related to respondent's pursuit of meritless claims, false information in an affidavit, and presence of Owens' false testimony changing version of events. Let me see here. Yeah. June, July, August, all the same. Same season and month are used synonymously. They're just all one. We just loop them all together. I was going to. Okay, we're almost done with this. All right. I was just looking to see, like, I know how many pages it was, but some of it's exhibits. All right. Ah, yeah, he's very creepy. He reminds me of the weird guy in Grandma's Boy, if you've ever seen that movie. Let me see. I bet I can find a picture of it. Let's see if I can find a picture. Ah, where did it go? Okay, let me share this real quick. Okay, present, share screen. Oh man, hold on. Yeah, he looks like this dude from Grandma's Boy. That's what he reminds me of. All right. Based on the conduct set forth above, respondent violated ER 1.3 by failing to act with reasonable diligence in representing Owens ER 3.1 by asserting or contravening issues when he did not have a good faith basis in law and fact for doing so that was not frivolous. ER 3.3a and b by knowingly failing to take reasonable remedial measures when he knew that Owens intended to engage in, was engaging in, or had engaged in criminal or fraudulent conduct related to the paternity case, ER 3.4c, by knowingly disobeying an obligation under the rules of the court. ER 8.4c, by engaging in conduct involving in dishonesty, fraud, deceit, or misrepresentations. Yeah, you can't let your client do that. ER 8.4d, by engaging in conduct prejudicial to the administration of justice, and Rule 54c, I think it's 54c, knowingly violating any rule or order of the court. Yeah. He doesn't care. Non-meritorious appeal. This one is weak. I don't even know why they brought it. That he filed an appeal, of the attorney's fees and costs on September 9, 2024. They filed a brief with the Division 2 of Arizona Courts of Appeals, which included non-meritorious arguments. Respondent falsely asserted that Judge Mata ordered sanctions under Rule 26, which we know she didn't. that, nothing was based in that they were not based on the facts, so they did not have any bearing on the propriety of the fees awards. Respondent failed to meaningfully challenge Judge Mata's findings of fact, and respondent's position on appeal was unreasonable in part because of his Rule 26 argument was not grounded in law or fact, and his assertions that Judge Mata was biased and committed structural error failed to meaningfully address her rulings that ignored applicable law. Yeah, it's just a bunch of speculations. On March 28, 2025, Division 2 of Arizona Court of Appeals issued a memorandum decision denying Owens' appeals. The Court of Appeals memorandum decision stated in part, "We note that significant portions of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly in the order, written in the order, awarded attorney's fees and costs under ARS 25-24 and 25-415. Nowhere in her order did she state she did anything under Rule 26. None of these scenarios by Owens have any bearings on the propriety of the fees awarded in this case, as the determination must be based not on conjecture, but on what actually occurred. Not in your Delulu fantasy world, where anybody that has a disagreement with either one of you, like, he just cannot stand being wrong. And I know so many people like this, and it's exhausting to deal with them. And you're just like, okay, like, say whatever you want. Like, doesn't mean you're right. You can say it all day, doesn't make it true. The Superior Court also concluded that 25-324B applied because Owens had provided false testimony as to the viability of the pregnancy and had sent Eckert a letter prior to her deposition that indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. And now that we've seen the real estate stuff, which I will continue putting out the parts for that, but I don't think she would have even gotten 1.4 million out of him, even if she tried to sue him for that stuff, because she turned down the right to get one of those properties that she could have. Because the guy was like, yeah, let's go, let's move on it. And she's like, yeah, no, now that Clayton's not a part of it, I don't want to have anything to do with it. On appeal, Owens does not meaningfully challenge these Superior Court findings, but instead argues that 25-324 does not apply in paternity cases. And the appeals court says, you're dumb. Section 25-415A3 states that the court shall, not may, shall sanction a litigant for cost and reasonable attorney's fees incurred by any adverse party if the court finds that the litigant violated a court order. Compelling disclosure or discovery. Here, the court made such findings, thus it was required. Yeah, shall, must. She has no other choice but to. She wouldn't have been doing her job had she not sanctioned Owens for the cost and reasonable attorney's fees Eckert had incurred. Owens does not meaningfully challenge that finding. Section 25-415A3 provides two exceptions if the court finds the failure to obey the order was substantially justified, or that the other circumstances make an award for expenses unjust. It is not required to impose sanctions. The trial court made no such findings here. No, because there was no justified reasoning in why none of this shit was disclosed, or that she lied about all this stuff. No justification. Owens' position on appeal is unreasonable. Her Rule 26 argument is not grounded in law or fact. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's ruling below, and also ignores the applicable jurisprudence. We therefore award Eckert his reasonable attorney's fees and costs on the appeal. Violations related to the non-meritorious appeal. So I don't know if you've noticed what they're doing. They're like, here's what happened. And then the next section is, here's how it violated the rules. By engaging in the conduct, respondent violated ER 1.3 by failing to act with reasonable diligence in representing Owens. Rule 3.1 by asserting or controverting issue on appeal when he did not have a good faith basis in law or fact for doing so. That was not frivolous. And ER 8.4D by engaging in conduct prejudicial to the administration of justice. Now, I'm wondering if this one is the fact that Owens is now on the hook. Like, sure, Owens wanted to appeal, but Owens is now on the hook because of her attorney's shitty job in writing an appeal that was based in fact or law. So maybe Gingras should have to pay that to Eckert. Because, I mean, yeah, I was on Laura's behalf, and so I know she does it, and she trusted Gingras to do it, and she's like, yeah, sure, send it over. But Gingras did a disservice to Laura here. Gingras, by submitting the appeal that he did, cost Laura money, which is not him representing his client in the best way possible. He hurt his client financially because of this stupid ass appeal that he filed. And now she's on the hook for more money. It cost her more money because of his stupidity. And then this is dated State Bar of Arizona by Jim Lee. Exhibit A. That's about guess what Laura's weight was on November 14th. It's right there in the records, which Clayton's lawyer has. Okay, and you can read the number for yourself, and then that is sealed to a court. That is sealed due to a court order. Exhibit B. Oh, what just happened there? Dang it. Let me go to the post. Stop sharing that. Where? Here it is. Okay. The notice of appeal must be filed within 30 days of the judgment. Annoyingly, but not surprisingly, Mata screwed up the form. A final judgment. It doesn't contain stuff required by the rules. Shocker. We could ask her to fix this, but that would be a waste of time. That is Gingras' Twitter. Exhibit C. No, the judge committing a crime was completely unnecessary. C. Law Cornell. Me explaining how this made Laura feel was entirely necessary, legal, and ethical. I hope no judge ever violates your rights and treats you this way. But if they did, how would you feel? So that was what he said there. Exhibit D was his PSA warning to everybody, because everybody goes to Gingras' blog to find out about judges, I guess, in Arizona. More of the blog. Exhibit E. Let's see. On July 2nd, 2023, while traveling in Southern, I think this is a part of the affidavit. On July 2nd, 2023, while traveling in Southern California, I made an appointment with Planned Parenthood for the purpose of obtaining pills to medically terminate the pregnancy. See, if she would have just said that part, that she made an appointment with them, that might have been fine. Maybe the date's not fine, but that would have been fine. Because we know she made an appointment. But then when she says, my mother drove me to Planned Parenthood location on the 2nd, but she did not come into the facility with me, because she can't be saying, oh, well, like, because they would be able to ask Jan. We know Jan would lie for her, or Jan would know the truth if she went inside, but none of this happened. So I took a photo of the sonogram screen with my phone, but I did not want Clayton to know where I had gone for the appointment. To conceal that information, I modified the image to change the facility name from Planned Parenthood to Smile. This says Scottsdale Medical Imaging, but it's actually Southwest Medical Imaging. I don't know. I also changed the dates from July 2nd to July 7th. A copy of the modified sonogram image is shown below. Record is sealed. Other than changing the top part of the image to alter the facility name and date, I did not change any part of the image. Exactly. And they're not supposed to make those statements. You cannot say that she was pregnant. You can say it is consistent with, in my medical opinion, this. Yeah, and he can't say that she was pregnant. My belief is that she was. He did fail. He did fail. So I will concede, Bruce, he did fail. I also just think he had bad information as well. And he's just a shitty expert. I don't know where they found him. I mean, maybe the cemetery at the graveyard. I don't know. Exactly. It's not like, oh, this is me. I didn't want him to know where they went. But you're not there anymore. So why, after this date that you're no longer at Planned Parenthood, does it matter that you were there? If you went on July 2nd, if he showed up July 3rd, because he found out the next day, what does that matter? Because you're not going to be there. It makes no sense. None whatsoever. I've never understood that. That's reasonable people, though. Mispronounced name. And we know we're not dealing with reasonable people. Yeah, but we know there was no future appointments, but yeah, the past stuff, I didn't want him to know where I had been. No, you just don't tell people where you're currently at or where you're going in the future. But if it's behind you, it's already happened. Nothing can go back and change that. But we live in reality. These people do not. But she says she did not change any part of the image. And she may not have changed any part of the image per se. She changed the details and the fact that even if the image isn't changed, it's not her image. So it doesn't matter. But that is the bar complaint from Dingus, or for Dingus. We will go over tomorrow, I guess, we will go over his response. Yes, the TARDIS. Yes, the TARDIS. This is not where the TARDIS is. This is also not Bill and Ted's Excellent Adventure. Clayton and Woodnick's Excellent Adventure. This is not any of that. So tomorrow, let's plan on going over Dingus's response. We will see if I have information or if I have time for blogs and stuff. Otherwise, that will have to wait till Thursday. But we will get through this. And then this week, I will finish up all the real estate stuff. And after this week, I will be caught up on everything that has happened. And hopefully, if I have to be out for an extended time again, not so much stuff comes out again. Because it's one thing to just hop on and do a quick video. It's another thing when there are just pages and pages and pages of stuff that have to be done. But thank y'all for coming and hanging out with me while I did this. Thank you, replay crew. Don't forget to like and subscribe. Comment down below. Share this out if you want. And I will see y'all tomorrow. And let's end. We'll just end with the other rap intro. We'll use it as an outro today. So, y'all have a good rest of your night, day, weekend, whenever you're watching this. Bye.
Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. I'm sparking revolution, it's a truth-telling tale.